What is the purpose of the distinctiveness requirement for trademarks? The fundamental requirement for a trademark is distinctiveness. This requirement is analogous to the requirement for novelty in patent rights and originality in copyright. Without distinctiveness, there can be no trademark. As Miller and Davis note, naturally, a trademark must be distinctive if it is to serve the function of identifying the origin of goods and thereby avoid confusion, deception, or mistake. If a trademark is to protect purchasers from confusion over what they are purchasing, then the trademark somehow must be recognizable, identifiable, and different from other marks. Some trade and service marks achieve distinction via their inherent nature. Nike's curved swoosh checkmark suggesting speed and agility, for example. But other marks gain distinctiveness as a result of marketing, forming a powerful association over time in the minds of consumers. For example, the term Raisin Bran is merely descriptive of the cereal and would not be eligible for trademark registration had Kellogg Company not demonstrated through evidence of use, including sales, advertising expenditures, and consumer surveys, that the buying public had come to associate Raisin Bran with this particular Kellogg cereal. The public's distinct association of a trademark with a company is known as secondary meaning, and it can only be established over time. How is distinctiveness determined? In the 1976 case, Abercrombie & Fitch Company versus Hunting World, Inc., Judge Henry Jacob Friendly established a 5-category spectrum of distinctiveness: fanciful marks, arbitrary marks, suggestive marks, descriptive marks, and generic marks. Judge Friendly's spectrum ranges from words and symbols invented solely to distinguish a product or vendor to words and symbols common enough to be ineligible for trademark protection. Fanciful marks are invented words, symbols, or devices that have no relation to the good or service being sold and have no meaning other than to distinctly identify the product or service and distinguish it from those of any other vendor. Some examples of fanciful marks are Xerox, Google, and Kodak. Fanciful marks are considered the strongest type of mark and are automatically registrable with the USPTO. Arbitrary marks are real words in common usage that have no descriptive relationship to the product or service being sold. Examples of arbitrary marks include Apple for the computer company and Galaxy for the mobile phone. Arbitrary marks are also unreservedly eligible for trademark registration. Suggestive marks are marks that imply a quality or characteristic of the goods and services being sold. Examples include iPad for the tablet computer and Coppertone for the sunscreen lotion. While suggestive marks are inherently registrable, any less distinctive marks would require evidence to indicate a secondary meaning. A descriptive mark explicitly describes the purpose, nature, or an attribute of a product or service, and are, therefore, not eligible for trademark registration unless a secondary meaning or association has been developed in the public's mind through usage. Ineligible descriptive marks include lightweight and faster. However, if a descriptive mark takes on a secondary meaning in the public mind, Sharp televisions, for example, or Windows for windowing software, then it can be eligible for trademark registration. The bar against descriptive marks is designed to protect common concepts and language that everyone needs to use. Imagine having to pay the coiner of the term reverse mortgage every time you wanted to describe such a financial arrangement. It would create a nightmare of social costs, which can be prevented simply by keeping the term in the public domain. The bar against descriptive marks spotlights the social purpose of trademarks, which is to prevent fraud and confusion in the market while protecting against any monopolies. The last and least distinctive category of marks are generic marks that are simply the common name for the goods and services being sold. An example of a generic mark might be the use of the word baskets for a basket store without any accompanying logo or design element to distinguish from a generic description of the items sold. A generic mark is never eligible for registration, no matter how much evidence a mark owner offers that it has acquired a secondary meaning through advertising and marketing. Ironically, a product or service can become so familiar in the marketplace that the public begins to associate its trademark with an entire category of similar products and services. When this happens, a valid trademark can become a generic name and the trademark will be lost, as happened with both cellophane and aspirin. Companies like Kleenex, Xerox, and more recently, Google have gone to great legal and advertising expense to prevent the generic misuse of their trademarks so these remain valid. Adobe, for example, sent emails to many web authors advising them to discontinue using the term photoshopped and instead say that their photos were modified by Adobe Photoshop software.